Okay. Okay, welcome everybody. Oh boy, that's Thursday morning energy right there. Okay. Oh, all right, this guy's good. So 8:30, Thursday morning, RSA, right? After the pub crawl, after all the social events, you are here to hear conversation about cybersecurity and the law. You're making me proud. You must want to be here. Either that or you're in the wrong session, so we're not offended if you up and leave. But welcome. This is a little bit of a different kind of a presentation for you all about one of the topics. So I'm a lifelong, 47 years now and counting, cyber geek. Grew up in the National Security Agency, now with the Center for Internet Security. Lived my life in technology and all that kind of stuff. But this topic is at the heart of some of the most important changes that are happening and need to happen across our industry. So I hope you feel the same after this conversation. Our format today, each of us is going to take about 5 minutes to kind of set the context, make sure that you see our perspective. Two distinguished gentlemen here joining me. I've never been around so many cool lawyers since I left the National Security Agency, but these are friendly ones, so it's a much easier audience that I got to work with. And let me talk, and so we'll do the 5 minutes each, set it up for you, talk about some things that are going on. And then we're going to give you, it'll be a bit of a conversation among the three of us. This is a complicated topic. I thought cybersecurity and technology was complicated, but when I get to talk to lawyers, my head spins. But these are both complicated, but also socially important. So we're going to give you a little discussion, kind of our perspectives, behind the scene, the thinking. Literally 1 minute ago, the Center for Internet Security hit go on, I think, on a paper to be released to the public on exactly this topic, and I'll mention that when we get to it in just a second. So you'll have a place to go to kind of read the background. This will help you understand the thinking, the issues, the rationale, and some of the things that we had to consider to put some of this down on paper. We do not have the ultimate answer to this, much to your surprise, I'm sure, but we wanted to start the national conversation about these kinds of issues. We'll leave time at the end for questions and answers. If you're shy about questions, we'll make them up. Don't worry. We'll talk about this. This is going to be a lot going on around this. So sound good? Okay, that's our format here. So let me explain the title, Oxymoron or Opportunity. I dreamed this up because this is the stuff I do. Oxymoron. Let me tell you a story. So I started in 1977. My first assignment at the National Security Agency as an intern, the Computer Security Design Guidance Division. I didn't even know there was such a thing as computer security. I barely could use a computer in 1977. But I'm in with some of the wizards. Anyone remember things like Orange Book, Rainbow Series, right? Some of the wizards that went on, sorry, oh, we should get the autographed. Some of those folks were the wizards that went on to later in the sort of 80s to codify a lot of the basic technical concepts underlying computer security. And I'm the dumb intern kid, green as grass. And we call them graybeards, right? Because they had gray beards. But back then, everybody drank coffee all day and half of them smoked all day. So the graybeards around the coffee pod stroking their gray beards. Somehow I became one. And the graybeards are talking, and I'm listening because I want to learn the wisdom of the ages here. And the one says, any day now, the first big court case is going to prove those vendors can't sell buggy software to us anymore. And I'm the kid on the sideline going, yeah, that sounds pretty reasonable to me, right? That makes sense. Yeah, buggy, how can you sell us known flawed products? Of course. We're almost 50 years later, right, debating the same fundamental issues of responsibility, of reasonable behavior, right? Who's responsible for what? We're sorting that out all the time. And that's the nature of this business. But it's also what's happened, and I'll offer the observation here. There's been a big shift in the discussion in the last few years, right? It's moved from how are we going to secure all our technology? How are we going to build the perfect operating system? Are you secure, yes or no? That's an old question and an outdated question. The question today is, are you behaving responsibly? You're making a lot of complicated decisions. Cyber is moving from, hey, the cyber geeks, are we secure yet? And they give you a lot of gobbledygook about how many scans and all that kind of stuff. This is moving, you've watched it, you're a part of it, into the boardrooms, into the thinking of insurance companies, regulators, legislators. And the question is less about, are we at some magical state of security? It's, are we making decisions responsibly? And that's a really important part of it. It puts cyber in the risk domain of enterprise choices, of risk decision making. But I think there's some changes that need to happen to speed that up and to make it relevant and important. So we've been discussing that at the Center for Internet Security for the last couple of years. And If you're not familiar with our work, we're a nonprofit. After I left government, I retired from government and spending my life in nonprofit stuff. And one of the things that really draws us to this topic is we are the multi-state ISAC, if you know what that is, Information Sharing Analysis Center. My folks tell me there's 20,000 state, local, tribal, territorial governments that are part of the ISAC. We're also the Election Infrastructure ISAC. You can imagine what that's like. But we're also one of the world's largest independent producers of security guidance. You might know us as the home of the CIS benchmarks, the CIS critical security controls. So we get to see the technology side, but we deal every minute of every day, around the clock, with state and local governments who feel the problem personally, right? It's their citizens that are directly affected, the businesses doing business in their state that really have to live with the consequences. So they're the place where the experimentation happens, where things are changing more rapidly. And so that gives us a chance to pull that together. So what you're seeing here, we put together a working group of some amazing people, judges, lawyers, consultants, technologists, to try and think through some of these issues, put them down on paper, start this conversation, talk about, from a technology side, what are the important things we should be expecting, doing, putting down, requiring to support the notion of large-scale public policy, right, of rational decision-making. And the magic term of art, and this surprises me as an old math wonk here, how often reasonable gets used in all this, and it's an undefined term. And we'll talk some about what that means and how we kind of flesh out that definition of reasonable, right? And it's not a simple one-liner, it's a complicated problem, but it's something we all have to make progress on. So that's the perspective. Again, I'm the geekiest by far here. These are two brilliant legal minds, again, but it's been a great learning experience for me and often humbling to, I always thought the law was like binary, right? You follow it or you don't. Much to my surprise, it's incredibly analog and messy, and so you'll get a sense of that as we talk our way through it. So that's my context of this, the work of the Center for Internet Security. You know, our job is to help us all as a whole make sense of this problem, figure out what to do, help you deal with the problems that you're struggling with, right? How much security is enough? The answer I grew up with is, the answer is, whatever you've done, you need more. And I can tell you 5 other flaws in your system that you need to fix. So what I'm asking, what I was asking you to do traditionally is bankrupt your company in the name of better security. That's not the best decision I've ever heard of, right? So in order for us to all thrive, we need to tackle this issue right at its heart. So this is our attempt to start that conversation with you all. With that, let me turn it over to my friend Brian Ray. Brian?
Thanks, Tony. I'm Brian Ray. I am a law professor at Cleveland State University College of Law, where I co-founded and direct the Center for Cybersecurity and Privacy Protection. I'm still a real dilettante in the field, although I've been working in it for about 10 years. Was not a tech geek at all. I came to tech dabbling in electronic discovery and eventually figured out, hey, lawyers need to understand technology, and evolved into this field. I'm also part of Ohio's, of Cyber Ohio, which is Ohio's major policy body that helps the governor, the executive primarily, but also the legislature think about cybersecurity issues. It was the creation of then Attorney General Mike DeWine, who's now the governor. And its real genesis was concerned by companies within Ohio about exactly the problem that Tony framed, which is how can we know what reasonable security is? And not surprisingly, several of these were large companies that had suffered breaches, felt that they had been doing things that were reasonable otherwise, and had been caught out by something that they either couldn't have anticipated or saw but correctly didn't prioritize. And so the first thing that Cyber Ohio did was put out this legislative proposal that became the Ohio Data Protection Act. Before I get into a few of the details, Tony and I traffic in similar metaphors. I tell my law students when they come to me, you think, as Tony apparently did, that law is magic, and that you're training to become a wizard, and that you will be able to then, after you finish your 3 years, cast spells that will then decide, that law X means Y, and that you will have answers for clients. And I explain to them, you're not. You're a risk manager. Law is almost never black and white. Law is about helping your client position itself within its risk appetite close to the line or far away from the line, and then also when there are activities that go over the line, telling them crisply and clearly, you're over the line. And so reasonableness as a concept is familiar to us lawyers. It is embedded in common law, tort law, other things. We're comfortable, and we train our students to be comfortable talking about these as, we don't always explicitly define it as a risk analysis, but at bottom that's what it is. It's arguments about whether certain conduct either crosses that line or doesn't cross that line, and there's always room for debate. So when Cyber Ohio was considering, well, how do we do this? How do we evolve and provide some specificity, some prescriptions without creating a check the box, right? Because of course the opposite of pure reasonableness is a rule-based approach, and the problem with the rule-based approach is it's always both under and over-inclusive. You're never going to actually capture the full problem. Sometimes you will, and sometimes you won't. And if you use a rule-based approach and you embed it in law, well, then that becomes the requirement, and then there's no room for argument. And so we absolutely didn't want to do that. And so we evolved to the idea that, well, look, it's not as if there's nothing out there in the world, that every time that there's a data breach, we're looking at it fresh. Of course, there had been a lot of good work done by a range of groups. There are laws out there that operate with various levels of specificity. So the idea is, let's kind of take all those things. If you're already regulated under one of these federal laws that require certain things, well, we're not going to make you do double duty. We're not going to say that you need to do something else. If you are complying with those laws, and it's possible to comply with laws, then that'll be the standard for you when you're operating in the ambit of where that law falls. So, for example, take HIPAA. When you're dealing with protected health information, well, if there's a breach and there's a tort action in Ohio, that ought to be the standard for you. Of course, just because you're a covered entity, if you are also taking credit card information, it's not good enough to be doing what HIPAA says. You also need to be doing what PCI DSS says. So it's a little more complicated in practice, but the idea was, hey, if you're already doing these things, you ought to get the opportunity to make the argument in the form of affirmative defense that I was being reasonable and point to something more concrete than just an open-ended, hey, let's get the experts out and talk about what's reasonable. In addition, for entities not covered by one of these laws, we decided to pull in these major industry frameworks, varieties of NIST, of course, being the most commonly cited ones and the ones that are mapped to, but also the CIS controls. And to be honest, when we were developing this, I mean, there were some really good discussions and debates. One of the things we said is, well, complying with PCI DSS isn't sort of good enough. That is a little bit too prescriptive. You need to also then be demonstrating reasonable conformity with one of these others. But we didn't really drill down into exactly what it might mean. I had an opportunity about a year after it was passed to write a white paper with another law profit at Ohio State. And it was really interesting to go in and then think through, well, how might this work? And I think the expectation on the part of some of the organizations was, well, this might be a get-out-of-jail-free card. This might be, hey, I can somehow demonstrate conformity in a really concrete way and win on a motion to dismiss, for example, at the very beginning stages before you even get to fact discovery, or at a minimum on summary judgment. Well, at least from my lights in the analysis that we did, I don't think it works that way. You're still going to have a discussion around, and you're still going to need probably to get some experts to develop evidence to show, hey, we actually were doing these things. There was a defensible reason we picked the framework that we did, and the things that we did, and especially when you think about NIST and the ability to titrate your risk appetite and to make decisions about when certain things are either well outside of foreseeability and low enough risk that we can deprioritize them. You're always going to have a debate about it. But at least now we're talking about some concrete things that people can argue about whether choices you made about why you did or did not do those things. And as we'll get into a little bit more today, what I didn't fully appreciate at the time, but as I've done more work in this area and especially partnered with CIS on a range of things, is these frameworks sit on what you can think of as a continuum of specificity. The laws do as well, but when we think about the frameworks, with CIS sitting sort of further to one end. And so one of the things that we've seen, and the Ohio Data Protection Act, by the way, was been something of a model in part because of the good work of CIS for a couple of other states who have adopted it, and there are several others who have thought about it. But in addition to this emergence of what we call the safe harbor laws, we've also seen a range of other activities at the state level that are starting to push, and at the federal level for that matter, but at the state level in particular, that are pushing towards more specificity. So we're seeing new state privacy laws, sometimes bespoke state laws that are going beyond pure reasonableness. And the other activity, and we map this out in more detail in the white paper that we're seeing, is some state attorneys general, when they use their authority to investigate after a breach, are issuing consent decrees that are beginning to do similar things to the safe harbor laws. In other words, saying, hey, as part of the consent decree, not just you agree to engage in reasonable security practices going forward, but that means something more specific, i.e. that you are conforming to one or more of these frameworks. And so we're seeing this evolution, which makes sense, right? Because we're well past the point where reasonableness ought to be up for pure debate. And the term that I would use when you're trying to think about how to either qualify for one of these acts or how to use the frameworks generically because you're in a state that doesn't have one of these acts is defensibility, right? And that's the notion that, hey, I am going to, and it's nothing new. It's what a risk assessment does anyways. Mm-hmm. I'm making reasonable choices that are data-driven, that are comprehensive enough that I can justify why I did them. And if something happens to me that, especially something that is triggered on something I deprioritized as lower risk, I can explain that and might have an argument to win against an investigation by a regulator, convince a regulator. And we do a lot of work, especially with state attorneys generals, who will tell us, yes, if I go in and somebody shows me, hey, I thought about this stuff, I have documentation, we did all these things and we still got hit, they'll, for the most part, walk away and say, okay, this is not a winnable case. All right, so with that background, I'm gonna then turn it over to our distinguished jurist.
Yeah, I don't know about that. My name is Sam Thama, and I am a judge in my day job, but I'm here as a volunteer, okay? So I'm not here in my official capacity as a judicial officer, so we can kind of exhale. But I do have some...
The official disclaimer.
Well, yeah, exactly, yeah. So, but we do, I do have some thoughts on this, and I was delighted to be included in this white paper effort. You know how in any good group, you want somebody in the group that knows absolutely nothing about what you're talking about? Well, that's me, okay? So Tony and Brian know things I don't. And that's by design. And not only do I not know things as a generalist on the Court of Appeals for 13 years where we hear all types of cases, civil, criminal, family, juvenile, state and local tax, probate, administrative. I'm a specialized generalist or a generalized specialist, however you want to refer. And I love that. I love that. And I love the courts. And I think we do a good job. But one of the, if you remember nothing else of what I say today, and it's fair that you won't, because you should listen to these two, I would love it if these kinds of cases never hit the courts. Right. And I'll tell you why as we kind of spend a little more time talking about that. But I'm in a group of technologists, right? The room is filled with people who know technology. I'm the least savvy technology person in this room. I'm confident of that because I'm the least savvy technology person in any room. Right? I have no background. I have an undergraduate degree in agricultural journalism. How many people hold that, right? And I grew up on a farm wanting to be a veterinarian, right? So I'm not even one of those kids in 4th grade that knew they wanted to be a judge or a lawyer. That's not me. I'm kind of a dabbler. The one closest thing, we have a daughter who went to MIT in undergrad and grad school in computer science. And so she tolerates me when I have questions about things like that. And I worked then at 2 big law firms, Arnold & Porter in Washington, D.C., and then Brown & Bain and Perkins Coie in Phoenix. Perkins Coie is based in Seattle. And they do a ton of intellectual property work, right? Smart people doing tech work. That wasn't me. I was the dumb property litigator when I was in private practice. And then I went to state court, where I served in 2 major rotations, juvenile court for 3 years, and then family court for 2, and now I've been on the Court of Appeals, like I said, for about 13 years. In the course of all of that, I've looked really hard at what the highest and best use of the judiciary is and can be. We've got smart people on the court. We've got people that work hard. They've got people that try to call things straight up without regard to, personal peril and political issues, notwithstanding what you hear in the press. But we're generalists. We're generalists. A lot of my colleagues came from criminal law, and they're great. They're great. I love working with them. But the thought that they're going to know by heart 1%, and that includes me, 1% of what you knew when you came in this room is not a reasonable expectation. And lest you think you want to, test these things in court, wouldn't that be fun, right? Wouldn't that be fun? How many people have ever testified in open court? Did you enjoy that? Right. The answer is no. People that you want to hang out with and socialize, other than maybe trial lawyers, don't want to hang out in court, right? They don't. It's an artificial environment. It's an environment that is binary. And we decide who wins and who loses, and that's our job, right? But if you can avoid putting yourself in the jaws of that, and that's all of what we're here about, is some tools to try to avoid getting drugged into court. I'm all in favor of that. And don't for a minute think that you'll hurt my feelings because our case volume will go down and courts will be sort of less essential. I've thought about that for a long time. I would have been really happy if parents treated their kids better and they never came to juvenile court. And I'd be really happy if people didn't commit crimes, including killing other people, and I never saw them in my criminal court. And if you do these things right, really focus on reasonable security, cybersecurity, and however that is defined, and reasonableness is a trick, you won't hurt my feelings. I'd be happy, happy, happy for that case to never hit the court. I'd be happy for data breaches not to occur. They're gonna, I get that. But if we can take measures, and by we I mean you, to see what we can do to avoid all that mischief and drama and the negative sum game that is litigation like that, it's a better day. We'll talk a little bit more about this white paper. There's some things in there that I really would commend you to reading. It's built in a hub and spoke way, so it's a long document, but the guts of it last maybe 20 pages. It's not one of these tomes that goes on and on and on. It has a series of appendices that add extraordinary value from my perspective. But reading the body of it doesn't go forever. And to the extent, one last point, to the extent I added any value in all of this, courts live in a sea of acronyms, right? But I never knew those acronyms, at least in criminal and civil when I came there. I don't know the acronyms in the tech world, and so the hope with this white paper is it starts with unpacking what those acronyms are, so dumb people like me can just begin to understand what the acronyms mean and how they kind of fit in a different sea of acronyms. So I'm excited to be here. I've never been to an RSA. I probably never will be, but I'm glad you're here.
But he did get some swag.
He still loved it.
No, he loved it.
No, I do. But that's because I'm a generalist and not in this realm, and I'm so happy to be a part of this and happy to be here.
No, wonderful. And so my two lawyer friends, actually, this is your second time at RSA, Brian?
It's my third.
Third, and for Sam, but to get a sense of the energy, the smartness, the neat people that are part of this business.
Yes.
I mean, I often say, again, I've been in this stuff a long time, I'm not sure we'll ever get better people and more dedicated, more talented than we have today.
If you came to a judicial conference or a bar convention, it would be quite a different feel. I swear to that.
So. That one's off the record, too. Yeah. So thanks, Sam. And I think that, so the paper, the word I had was it was released at, I think, it's released now. Does anyone know right off here? CIsecurity.org. So download it, no charge, enjoy it. We put that out there not because it's the ultimate answer, but because we've done a lot of hard thinking with a lot of varied inputs to it. And we think it stands strongly as a good context-setting, start of a conversation about this. Brian, let me, if you don't mind, Brian.
Yeah.
So, because what you said was really intriguing, this notion of law as risk management, right? And that sort of tells me, what we're trying to do is bridge a gap between sort of technology, security wizardry, and the elements of public policy, right? How do we make sense of this as a kind of social construction? And it seems to me that is the intersection, right? That there's a tremendous history of thinking about risk management and the evidence that supports it, making the case for defensibility in the tech side, but also in the law side. And that feels like where we've been aiming, right? And I think what that implies to me, and I'd love your opinion, is how do we, what it says, what it doesn't say is we should stand pat. What it does say to me is we should look at the artifacts that we have created to help make technical sense and sort of either recast, reframe, complement them with the information that brings us into that gap, right? That makes it easier for a Sam who doesn't grow up in this stuff to because he's going to have intelligent but plain English questions about those kinds of things. That's kind of the right place to meet and some of the artifacts and discussion.
Yeah, absolutely. And just to put a little bit of flesh on the bone. So when we think about this problem, I mean, it's a practical problem and a business problem for organizations because, of course, getting breached has consequences that go well beyond the legal risk involved. But the legal risk often drives and shapes the compliance, right? Because you're looking for things to point to and say, okay, I have to do this, this, and that. And then, of course, the challenge is we can't be too specific about it. The downside legal risks you're thinking about you are thinking about litigation and data breach litigations. They never get to court, right? I mean, except on ancillary issues around standing and damages. The question of reasonableness it just never gets adjudicated. On the regulatory side, it does, but it's done primarily through investigations and either by state AGs or federal regulators, and it tends to be a settlement, right? It tends to be an order that comes out. And it's on the one side, the managing the litigation risk and how do you really negotiate potentially around settlement there and the cost of that. And then likewise, the cost of settlement with a regulatory body. Did a panel at the conference that we hold with litigators who do this all the time in instant response, and one of the litigators said, well, the first thing I do is, I look at everything that happened, how many records, how serious was it? And then what did you do? What was your plan? How did you respond? What happened? And was it something you had thought about? And then, that gives me I can very quickly make an analysis around what's the number that a state AG, for example, it's the state AGs that typically are getting these fines, and what's my leverage in the federal context? And I said back to him, I said, well, can you really quantify that? And he said, yes, Brian, I can quantify that because I've done hundreds of these, and I know, I have an understanding. So when we think about it's not as if in the real world there isn't on the regulator side, more on the regulator side, and then plaintiffs as well. The plaintiff's analysis is a little bit different, but the regulators really are looking at, did you do your job? Is there something here for us to focus on? Because they have to pick and choose. And then in a kind of further down the line is a thought about somebody like Sam, would I be able to defend on that? But that tends to translate into how do I negotiate with the plaintiffs? The problem, or one of the problems as I see it right now, is it's driven by factors that aren't necessarily related to the stuff that CIS is trying to do and that the state laws are trying to do, which is, were you actually reasonable, right? It's driven by how many records and things like that. To some extent, it's driven by the choices you made and how egregious were the lapses. But what we're trying to do is kind of push that conversation away from some of the metrics that drive data breach and the numbers in data breach into considerations around, were you doing the right things? Yeah. Did you have the right kind of analysis?
Yeah.
And law, right. and I mean, when I first taught a risk assessment course, I didn't really understand how to do risk assessments. I partnered with a technical colleague. It was eye-opening to me to understand, okay, this is how this works. And it was a complete epiphany that NIST allows you to select your risk appetite, but that was something different.
No, it gets right. And that description there, right, it provides opportunities from the, say, technology security requirement side to help create the artifacts that make the case, right, that make it defensible. They should be a byproduct of sort of doing the right thing, produces things that you can be presented, right? Can be explained to others and shown. So that's one of the, I think, intersection points to think about. Sam, did you have a thought about that?
No, I completely agree. I really don't have anything to add on that.
Yeah. I think, and just for reference, this is a slightly older version of one of the diagrams of the paper, the history of federal cybersecurity law. So one of the things we do in the paper is to sort of compile the story in one place. So as Sam said, the meat of the paper is 20 pages, very readable, but sort of put in one place a summary of these kinds of things and what's going on there. There's another, this is another thing I think we'd like to talk about, which is kind of the momentum here, right? Brian hit, for us at CIS, there was some earlier work in California, the Kamala Harris report, but really the momentum today started with the Ohio Data Protection Act, which really brought us kind of where we are today, and is the discussion point with us for other states. And a little more of the backdrop and sort of how it was received within the business community.
Yeah.
Right? So this wasn't sort of handed down from on high, but this is a pretty open negotiation.
Well, so it was Cyber Ohio tried to be consultative. It was a broad group, although Republican legislature, Republican governor, driven by mainly by corporations. We did consult, and there was a little bit of pushback by the plaintiffs' bar, but ultimately not really strong pushback. But again, the basic idea was, can we create a carrot as opposed to a stick to get organizations to actually grapple with the need to think about cybersecurity, and then for those organizations that were doing things and trying to be responsible, can we give them a target to shoot at? It's never been litigated, but of course that's not surprising because, as I said before, data breach class actions almost never reach the courts. Early anecdotal evidence by several large companies, some of whom weren't involved in Cyber Ohio itself, that it was helping in-house counsel to make the argument internally for resources, because now instead it gave them something more concrete to point at, and also to start to kind of quantify around, hey, if we can do this, and then this gets at some of the things that CIS is doing, we can reduce risk by X, and we've got then this this badge, for lack of a better word, or I don't know, this token. It's like getting your T-shirt in the place downstairs. Right now, I've got the token. If we do get sued, I can put it in the box, and maybe I'm going to get that reward, as opposed to just talking about reasonableness. So no hard data on it, but it certainly seemed to have created conversation. And then law firms, of course, do what law firms do, which is there were a lot of client development pieces around, hey, we can work with you to try to meet the requirements of the ODPA. And so, but more broadly, and what the earlier slide was showing, was it's really part of this history, right? Even in states that don't have these acts, you're seeing a real push, not surprisingly, like in a maturing environment, you're going to see a push towards there being some consensus around, or at least overlapping consensuses around, hey, this is the stuff we really ought to be doing, or at least you at a minimum need to think about doing in order to be reasonable. And there's, and if you're going to not do these things, well, you're going to have a pretty good reason, right? And that's sort of what these laws, and I don't think we thought about it quite that concretely. It was more a desire to have, again, that, that defense, that thing you could shoot for.
What really struck me when I first saw your work, Brian, in Ohio, was the incentivized voluntary adoption.
Right.
So I think I see some long-timers in this business here. We go through these cycles of voluntary action, mandatory. And the trend now is towards the required, mandatory, regulated. To sort of push things to better security. But we were really intrigued by this. How do we incentivize people, right? Which again moves the discussion from here's the security list, take it or leave it. Right. This is the formal definition, meet it or don't, to this, puts it as a business decision. I'm incentivized to take these actions because I get this benefit from it. And it's part of a broader set of risk management thinking, right, for an executive team. And that feels like the right place.
Yeah, and I'm glad you highlighted that, because that was in early discussions. Again, we did a lot of presentations around this. It was somewhat surprising to me, but that shift was apparently valuable. The fact that again, in-house counsel could talk to the CEO or the board and say, hey, we can get this benefit, felt qualitatively but significantly different than, hey, I'm trying to avoid risk. I'm trying to avoid, a penalty or something. It really did change.
No, it takes it from this sort of like, we're scared into action, right? Or we're inspired into action too. We're making a decision about action. Just a quick, Brian, but every state has worked out differently, right? When you look at these safe harbor statutes, can you give a couple examples? So different ways that different states have approached it.
Yeah, and so I mean, I'll pull out Connecticut, which is we worked with CIS in some of the negotiations for Connecticut. Connecticut was looking a lot like Ohio's. Ultimately, again, in political differences, the decision was to limit it to a defense against punitive damages, which is pretty limited. So, but when you think about the practicalities of Ohio, so first of all, we don't get that many data breach class actions. When I was doing this, and I'm a former litigator, I was skeptical of how much of an incentive it would create, because again, for the reasons we were talking about, these things never get to court. Like, am I really gonna? Yeah. And I was pleasantly surprised at how, both because it was affirmative and because it gave this concreteness, it really did seem to be having some effect. And we don't have data from Connecticut, but I think you probably can see a similar kind of effect even if you're in Connecticut. And then more broadly, because we're seeing other kinds of regulatory actions adopting something similar, it's just been interesting how it's without any direct connection in a lot of ways, these similar kinds of phenomena appearing in similar contexts, but without any apparent relationship.
And you know what it feels like to me? We all know in cyber that prevention is the wiser strategy than trying to react to incidents. But of course, we never learn that lesson. We just keep spending more on the tail end. But this sort of prevention to get to a SAM. All respect intended.
The issue with this too, I'm excited about the development in the states. Yeah. I absolutely am, and some of that's, I'm a state court judge, right? Because I apply state law, and I like that. I think sometimes state law is overlooked, not by Brian, but some academics, because the data set is so large and there's so much squalor in it. It's hard to find commonality, whereas federal law is complicated enough, but you have one data set, right? Well, this is exactly what states, I think, should be doing. And I'm excited about it. I'm really delighted by what Ohio has done and what you're hearing about from other states. The white paper has a fabulous summary of state laws, and it adds real value, and I'd commend that to you. Now, I'm a uniform law commissioner. I'm a dabbler, remember, in my sort of volunteer time. And the reason why when people used to write checks, that you could write a check in state 1 and then you could cash it in state 2 was something called the Uniform Commercial Code that was a product of the ULC. There is merit in seeing whether the ULC wants to undertake these. I don't know that they will, because we're not as nimble as what you've described. But the other thing, if you go and look, for those of you who look to annotate state statutes, and we meet on a street 18 years from now, and you say, hey, this Ohio law has never been litigated. What does that mean? Does that mean that the law failed? Or does that mean that the law succeeded?
Right.
And I think there's a really healthy argument that it may mean the law succeeded. I've had a hand in drafting model and uniform acts that hopefully will never get litigated, but their existence, their very existence on the statute books has meaning and hopefully improves behavior, especially for sophisticated corporate entities that not only are presumed to know the law, but probably actually know the law. And so my hope is that that may never get litigated, and I think that's a win, not a loss.
Yeah, of course, as a law professor to write articles, I'd really like to have a couple cases by smart judges who I can analyze. But and I know we're going to turn to questions real soon. But Tony, I just wanted to raise the issue we were talking about last night, which is so from my perspective, what the Ohio law did was create what I've called process-based reasonable security, which is defensibility around your process. Now, of course, you have to say the process has to produce things that you can then point to, but if you can demonstrate that you went through the informed decision making and you documented choices and you had data and reasons for it, then that's ultimately at the end of the day what you're going to say. And so then even if you are hit with a breach, you ought to be able to say, hey, look, that was something either I couldn't reasonably anticipate or I thought about but reasonably deprioritized. When we wrote the paper, or when we were starting to write the paper, I said, well, let's call this process-based reasonable security. But we had a little bit of discussion around it because one of the benefits of CIS is it's more prescriptive. So let's just talk a little bit about that.
Yeah, that's right. And as you raise that language, Brian, it really struck a chord, right? Because again, getting away from the sort of binary thinking about this, you're secure, you're not, you met the requirements, or you're not. Well, no matter how prescriptive, how small the list, whatever it is, you don't solve cyber in a day or a week or a month, right? You're putting in place governance and machinery and all the things that lots of you folks live out there. So the question is not, are you done? It's where are you? And what choices did you make to get there, right? And were they rational, reasonable? You're going to have to prioritize based, and then there's a lot of local context, the budget, right? The, heaven help us, the risk appetite issues, all that stuff has to be considered in real life. And so talking about it sort of openly, it is a process-driven thing. But, and the key is, as you said, at many stages, artifacts are created, or are naturally a byproduct of that become the notion that you can examine, present, and so forth. And I think those really matter. That makes a lot of sense. It's consistent with the way a lot of us think about the process things that we deal with. I think in tech we use process a little bit differently, but I think it's again a natural kind of meeting point for the legal argument, the discussion, the presentation, and so forth. But also it has caused us to rethink a little bit. Just because I made the slide, I have to put it up here. When we talk about the controls, for example, the internal catchphrase, it's not just about the list. Right? This is not stone tablets handed down high. We've been building an ecosystem. It's about what is available to help you achieve the good intentions. And if you look at that diagram, it starts a little bit small, but it's around how do I know these work? How do I get them? How do I learn from somebody else? How do I present the work in the context of a different framework? All these kinds of things are important, and they're things that we have been building towards, right? And they're closer to the SAM plain English questions. They take us away from the document A, B, or binary yes or no to the sort of presence, and many of these are artifacts or process things themselves. So this has helped us kind of rethink our, we've done a lot of things I think well and naturally, but we didn't really know how to talk about them. It says we sort of kind of have the common language now to think about it. And again, this is not a commercial for anything here, but a lot of these, to close that gap between, good techie, understand the attacks and do the controls, to public policy, right? The anchors that bring us in there. I think these are at least in the right direction and help us think much more clearly about it, help us bring the case or not to a SAM to think about. But again, it feels like a pretty good intersection point there to me.
Should we open for questions?
Yeah, so in the interest of time here, so we have a few more minutes. If you'd like a question, hop up to the microphone. You can direct it to one if you want, or just in general, please. Up front first, please. Thank you.
I have a general question. I've been, as I noted earlier, working on this since the Orange Book was important. We built a system that was A1, but our marketing people said they couldn't sell it. Yeah. So the question is, are you either 30 years too early or 30 years too late?
Maybe both.
In the sense, yeah, I think so. Because what is a reasonable behavior now? I assume you've seen the CISA report on Microsoft, which was the most damning language I've ever seen in a government report. But Microsoft...
I'm one of the authors, thank you. I'm one of the authors of that.
Good work, thank you. But Microsoft is a monopoly, so you want me to behave reasonably. I don't have any reasonable behavior. All I can do is buy Microsoft and know it's failing. And given the cost to the society of some of the failures we've seen, Colonial Pipeline, for example, way more than the $5 million they paid. The society can't afford this kind of lousy security. But I can't tell anybody, as a technologist, I can't say, here's how you fix it. I don't have a technique, because 30 years ago, you weren't there to force people to buy our secure system, which was more secure than anything that's been built since, as far as I can tell. So we have no secure systems to use.
No, absolutely.
So in that sense, you're 30 years too
I'll
late.
take this one.
And in the other sense, you're 20 years too early because, I'm sorry, in that sense, yeah, you're 20 years too early because until there are things like that,
Sure.
asking people to behave reasonably when there is no reasonable behavior
Right
is
in the
putting them in
middle.
an impossible
We're right in the
position.
We're right in the middle. We're
Yeah,
perfect.
right.
We got 5. Should we take 2 more quickly and then do a speed run to answer? Or?
Let me just add
Okay.
this quick, and just for the sake of, because some of these are complex topics, we'll be out in the hallway right afterwards to talk about questions if we don't get them. But quick answer. So I was working in that area at that time.
Yeah.
Some of the best minds on earth, with all respect, solved some of that most incredible tough technical problems there. But it really wasn't in alignment with the market, right? If the A1 didn't run PowerPoint, no one was going to buy it. And there were a lot of complex issues around that. What it told me of those days is it's not that the best technical answer will not win on its own. And so we need to think about these incentives and the public policy links and all that kind of stuff. The Microsoft issue, and I'll be happy to discuss it later, we talked about this last night.
Yeah.
The difference between an individual enterprise making a decision and then standing back and looking at the enterprise as a whole, right, the nation's economy. So many times enterprises can make a reasonable decision because they can't understand because it's so complex. I'm going to buy the company that has an FBI logo on their stuff down here in the floor. I'm going to buy the market leader, right? That's a safe choice from an enterprise that can't sort out this complexity. When you stand back and look at it nationally, as you're presenting here, right, it's a terrible choice. We have a monopoly. We're building high dependency on risk. So let's talk about that afterwards, if you don't mind. But there's a lot of, for me, the lesson of the 80s was the best tactical answer will never win on its own. All right, thank you. Next,
Yes.
back to the second mic, please. Go ahead.
Jessica Cohen, I'm a regulatory counsel for privacy and cybersecurity in-house. My question is, the state laws have a lot of optionality around what frameworks can be used, but we see on the federal level, we have the federal agencies are moving towards, instead of an or, more of an and seeing how, and also kind of stating that the NIST cybersecurity framework is not enough on its own. There are other controls that are needed. And so I'm curious from a public policy standpoint for companies that are looking for that optionality, how can we use the state laws to provide an example for federal agencies to follow if they're moving in this, what I would say is the wrong direction?
Yeah. I mean, I can take that real quickly. So the short answer is that this is part of this evolution we're seeing, right? And of course, it depends on what you're doing vis-a-vis the federal government. If you're worried about regulatory action, I think you can use what we're doing in the white paper, we're suggesting in the white paper to create that defensibility. The FTC's, they seem to be doing, they seem to be moving in a similar way, and there's nothing concrete. Now, if you're a vendor to the federal government, right, well, you're not going to have a choice, right? You're going to have to do those more specific things. And of course, we're seeing through the executive orders, again, a real push for more specificity. Now, part of what we say in the white paper, which is why I raised that issue, is the CIS controls actually provide a data-driven specificity that then leaves open this possibility to say, hey, certain controls we are not going to follow, we decide not to follow, or even if we didn't follow, they're not the cause of this breach. So you've got defensibility. But that's a hard reality, and I think that that's one of the downsides towards the move towards specificity is, of course, especially for smaller entities, it's going to get more complicated, right? And again, as a vendor, you're going to not have a choice, and this is, this is especially with DoD and others, you got.
And just a brief add-on, Brian. It's one of the reasons why we've committed CIS to provide a cross-mapping from what we do to all these other frameworks. So, because as Brian said, we're more prescriptive. Sort of technologists sort of use our view, but the boss wants to hear about NIST CSF or hear about it. So we provide, that's actually my son who does most of this, cross-mapping from, if you use ours as kind of your technical roadmap, you you can map to other things. NIST provides a cross-mapping framework and is looking at automation for those kinds of things. Because we recognize we're going to live in this complicated, evolving environment and multiple frameworks, but a lot of that is make work. We really need to simplify that, so that's our commitment from CIS. Was there another question someone may have given? Oh, coming up to the mic here. And thank you very much, great questions.
Yeah, thank you.
I think we can take
one more?
one quickly if you.
Okay, forgive me because I'm hoarse, but it's regarding cybersecurity insurance requirements. So where does that fit into reasonableness? And should holding that type of insurance similar to healthcare be a requirement for large vendors? Is having cyber insurance a crutch for large organizations, or do you have the opinion it's helpful and holds businesses accountable?
All right.
Yeah, I mean, we talk a lot about insurance, and the insurance requirements are evolving in the same way as Jessica just mentioned at the federal level, right? It gets a lot, the underwriting process is more concrete, I mean, I think there's some alignment here, right? If you're doing the kinds of things that good insurance underwriters are requiring, it ought to overlap considerably. In other words, insurance isn't interested in just imposing costs to impose costs, right? They're interested in actually trying to understand what is going to meaningfully reduce risk. Now, there's a prophylacticness to insurance. On the policy questions about whether to require it or not, I don't think insurance is a crutch. I mean, I think early days of insurance was, maybe it was just, maybe it was a reflexive risk shifting that wasn't as risk shifting as you might have thought it was. I think my sense is that the newer policies and the requirements are moving more towards meaningful, having a meaningful risk reduction effect, but I don't know that we would yet want to require it, although as a contract matter, most of the time vendors are requiring. I mean, CSU requires $500,000 of cyber insurance for
but it's fast evolving, and we are involved with lots of discussions we're happy to share with you later. All right, so our time is over. Thank you very much again. We appreciate you out here in the morning.
Thank you.
Thank you all.